300 to 800 years is what the Supreme Court found.
Do you have any idea how that was determined?
Well, they obviously had engineering data. I wasn't there, but I do know that the reason we're segregated from the Arkansas is that the Supreme Court found that water moving that slowly doesn't affect the Arkansas. And if you have movement through a body of water and through sand, it's going to move molecule to molecule. So from the top to the bottom, it's 300 to 800 years.
Can we get the location of your monitoring well?
Sure.
Sure. Are they in the report that was sent out?
They are.
They're in the report.
If you got a copy of the report,
I have a copy of the report.
Okay.
All I have is a copy of the
Are you on the email? Do you have an email? The mail is. We'll give you one. Any other questions?
Chris, I have one.
Go ahead.
I've irrigated on the upper end of the basin most of my lifetime, and our wells didn't drop off until the last 5 or 6 years, last 7 or 8 years. They didn't drop off. I have one well that pumped 1,400 gallons a minute. In the last 4 or 5 years, it'll start out about 1,000, and by fall, it's down to about 700.
You'd expect that.
Well, you're saying that you could pump this water if we never get no recharge. We could pump forever and not lower the basin. That's not true.
No, it's basin-wide. It's exactly what happens in Douglas County. The municipalities continue to have to drill deeper wells to get to the water, but basin-wide, the legislature has said that a sustainable supply is 1% depletion every year. And they've found the definition of sustainability in the legislature is 1%. So, and that's taking no recharge. I'm not saying we do that here. Austin was charged to find out what a sustainable ratio was, and it's 2 to 1.
So you're saying we're going to have to drill or just keep drilling deeper?
No, I said that's what the legislature found to be sustainable with no recharge. I'm saying that we have recharge here, and his calculation is based on sustainability with recharge. I'm just saying that in other basins where you got no recharge, they still find that you can drill wells that are sustainable over a long period of time.
The state engineer estimated that the recharge into your basin is about 23,000 acre feet per year.
And so where are we getting this recharge from? Rain, snow, or?
About 90% of it comes from the
Is
percolation
that
of
figured
rain,
on
and
a
about
10,
10%
12 inch
is
average rainfall, or is it figured on
Average.
1 to
That's
3?
average. That's average.
On a 10 to 12 inch average rainfall in the last 15 years, we haven't had 3 inches.
That's anecdotal.
Huh?
It's not basin-wide.
Basin-wide, you think they got more rain on the north end than we did on the south?
Sure.
So you're saying they're getting 10 to 15
I'm not
inches?
going to talk meteorology. What I'm saying is that over time, you take an average. That the plan that you have in place now that lets you pump was based on an average. It wasn't based on annual precept. It was based on an average.
Of what?
What they thought was sustainable for 35 CFS that you bought from the Box Springs. And they let people irrigate 5,300 acres. Now, whether they do it or not is up to them.
So what percentage did they said it was rechargeable from the irrigation itself?
That's what CU measures, and that's the ratio that he's talking about. How much gets used by the plant, how much blows when the sprinklers are sprinkling, and then how much goes back into the ground. That's how you get the 2 to 1 ratio.
his factor leaves those return flows that recharge out
Right.
in behind. It's not, we're not allowed to pump that and take it.
We aren't allowed to take that.
So, if you guys pump it out, there's not gonna be any return.
Right, that's why we take less than what we would have to
What
irrigate
you-
a crop.
When you
because-
irrigate, there's a portion that's return flow, and there's a portion that's depletion.
Right.
We're only exchanging that portion that's depletion.
So
We're
you-
now saying we're gonna put that to industrial use, where that is now 100%
So
depletion.
you say our depletion right now is 2 acre feet.
Yes.
That's conservative, because what you guys paid for when you bought the Box Springs rate was the ability to deplete about 2.7. That's the calculation he just gave you.
So you say on the average, we're pumping 4 acre foot. of
I'm
water.
not saying you individually. I'm
Well,
saying
Mr. Mason is-
the law that was passed by the court and approved by not only the legislature when they gave you a loan, but by the water court, allowed for 2.7. We're not saying we will take 2.7. We say 2 to be conservative.
Chris, when Jack asked me a while ago about the water moving from the north through the aquifer to the south, now, both questions stopped it at 94. Are you saying it takes 300 to 800 years for that water to flow from up there where you're at to 94, or all the way to the end of the basin in 300 to 800 years?
The Supreme Court found that the reason they could say that there is no effect of this basin on the Arkansas is that water in this basin takes between 300 and 800 years to affect the Arkansas. If you take a ditch and you start at one end, you got to have the molecules move. So the rate of movement is 300 to 800 years.
Yeah, to affect the Arkansas. That's a lot further south than 94. So that's what the question was, wasn't it, Jack? Yeah. From the north end to 94. So say 300 would be good.
Okay.
Estimates.
Okay.
Takes
300.
another 5 to go down there.
It's longer than I'll be around.
Yes. Than any of them.
If you get this change to industrial use, you're doing it now for oil and gas, fracking. Does that mean once you get, assuming you get this done, that you can do it for any other use other than oil and gas?
No, industrial, that's the only application we've got. And part of the reason for that is you can only change it if you have a contract.
Right.
And that's why we're bringing to you the opportunity, because we have a contract.
And that's why it's limited to the 500 acre feet of industrial.
If any of you went out and got a contract, you would have to go through this same process. And the other safeguard you have in terms of your own particular property right is we're not changing the use of your well. We're only adding industrial right to the augmentation. So those wells that don't have a contract don't get changed.
What all falls under industrial?
I'm sorry.
What all falls under industrial? I mean, besides oil and gas, what else would be an example of industrial use?
Well, that's what the contract's for, so it would be, I mean,
Fracking,
Fracking.
dust suppression, cleaning trucks, that's about it.
But it all has to do with oil and gas exploration then?
That's what the application
Mhm.
said.
I kind of find it a little bit funny that how many people here signed up with one of the realtors that the board brought us, 2 different realtors before, okay? And everybody knew that the water was going to be sold, okay? That's what it was for to sell, to go to somebody that was going to do this. How many people signed a contract for that? There was no discussion like this during that time at all. No one was concerned about it.
Well, you probably wouldn't be in the discussion right now. If you had the cash money to sell it and pay us, we'd probably be more
What's the
agreeable.
difference? If you're worried about injury and all this stuff, I mean, I understand that. No one's asking to use any more water than what
Just like I
was
said
already
before,
used.
Scott, all you gotta do is bring the money here and.
Well, I know.
And I'll sign the contract. You can
They
have it
don't
in place.
sign it. Well, he didn't have enough money, I know he did, but what is enough money? Are you worried about injury, or are you worried about money? What is it?
Well, depending on which way you
Well,
look at it.
injury can turn into money, one way or the other. If we can't
Well, we
irrigate
signed
our
up-
cro- no,
we
listen,
signed
if
up
we
to
can't
sell.
irrigate our crops,
I
thank you
agree.
for listening, if we can't irrigate our crops, that's injurable. We need to irrigate our crops so we can feed our cows.
I understand that. What I'm saying is, so the last deal we had here, so your neighbor sold, but you didn't sell, okay? But the person that bought most of the water, or all the water, if he injured you, there was no discussion about that. That's all I'm saying.
What was our system?
I have no idea what you're talking about.
How many people signed up to sell their water with the realtor from Wardway, or Brian Hancock?
I don't know.
I think recently, I'm going to ask this question. Recently, most of everybody here has gotten a call from a real estate company wanting to buy, well, has a buyer for water or for the irrigated ground in this basin. What do you know about that?
No, he hasn't talked to me.
So you don't know anything about it?
I've heard that he's been out offering, and to me, that's why it makes absolutely no sense not to get this change approved. Because the value, what I'm curious about, Jack, is when you have a value established for water on your books for this association, is it restricted to irrigation use only?
On what do you mean?
When you have a value, every year you give a report to this association about what the book value is of your assets. Is it limited to?
The Horse Creek Dog Tape, yeah. Okay, it's that value, and I think I got a footnote on it, is strictly based on the cost that we gave for the water rights when we acquired it.
Was it restricted to irrigation use? No, it wasn't. The loan document does not restrict it to irrigation use. That's why you've got some value.
Oh,
If
no,
you restricted it to irrigation use only, it wouldn't be worth a plug nickel.
No, I didn't, no, I just, that value on the balance sheet of the Horse Creek Water Use Association is based upon the value that it cost the association.
Which is what?
Well, would that value, $825,000, I think it is.
Well, the loan was based on what? It wasn't based on a restriction to irrigation use only.
What do you mean, what the loan was based on?
The
was based
loan
on what
from
we
the,
borrowed it to satisfy the service right.
to satisfy what?
The service rights that we had to buy, that we had to pay for Box Springs
And Reed and Smith.
and
Yeah.
Levy's.
Yeah, and then when we got the loan from the Colorado Water Conservation Board, you had to pass a statute that approved that loan. And there was no restriction to irrigation use only. Because as a matter of fact, the articles say that you can, the whole association is dedicated to making this the highest and best use of this water. And the best use is not restricting it to irrigation use by far. So it gets back to a question of injury. How do you calculate for those people that want to continue to irrigate injury? You do it with the safeguards that the state engineer is already requiring of us. You have a monitoring program. You only dry up land that's already been irrigated. You delineate what the land is. But then in order to protect the value, you don't, once you change it to industrial use, you don't restrict it to industrial use. You add industrial use so that if a guy wants to irrigate the next year, he can go back and irrigate all the ground it's got. So that's how you maximize value. And otherwise, if it was restricted to just irrigation use, I'm sure there's nobody that would just buy it when it's restricted to irrigated use, unless they want to buy a farm.
Well, you bought it, it was restricted.
Pardon?
When you bought them place up there, it was restricted.
No, it's never been restricted just to irrigation. This 2011 resolution, which said you got to meet these 4 proofs before you can change it, was exactly what we had in our hand before we bought the farm. And it's reasonable. It protects everybody. The new 5-page draft set locks the stuff up forever.
That's right. Because I drafted it, it doesn't.
Yeah,
The
and
purpose-
let me just read you, I'll read you number 9.
Let me
The
finish
board
what I'm saying.
reserves the right to modify these
The purpose
criteria.
that I did as the association's attorney, I was asked, okay, put together all the documents and figure out what criteria have to be met to change the augmentation. We didn't pick anything up, there's nothing new in there. What we did is the research we thought they had done, or should have done, is put together the decree for the augmentation, the CWCB loan, the settlement agreements of the association, the various documents that the association has to comply with, and put together the criteria. It may make it somewhat impractical for individuals to do, yes, but it doesn't lock it up. It doesn't say, no, you can't do it. What it is say, okay, here are the criteria that have to be met to protect the association and its obligations, which includes the obligation to protect the individual members and the obligation to comply with the augmentation plan and the settlement agreements that went into it, and the CWCB loan. And it may be that what is being contemplated, excuse me, won't mess with, you guys got some weeds running around, won't mess with the augmentation or the CWCB loan. That would be great. If they can get that right in CWCB, that would meet one of the criteria. But these criteria aren't new. What the problem was, and the reason the board asked me to do this, is make it easier for everyone to look at what the criteria are, and for the people who want to do this, and have it all in one place. Yes, it is extensive. Yes, there are some obstacles in there that, in practicality, are going to be, they can't prove right now. They just, there's no way they could prove right now that the individuals that sign settlement agreements with the association won't argue that the augmentation plan is now, and the agreements upon which it's based, become void because it was based upon agricultural irrigation and this changes it. But that's a process that has to be gone through that'll take some time, and it may be a process that can't be done until the augmentation plan is actually changed and gone through the court. But the association has the obligation to make sure that its obligations aren't interfered with as part of the process. And so that was the purpose of the criteria, was so everyone could have it in one place and wouldn't have to go through the 7 or 8 different documents that I had to go through and that took several hours, and it was to put it all in one place for everyone, for those who want to do something. It's not to prevent it.
So,
Would any of you spend a ton of money to try and meet 5 pages of requirements and then have the following 2 provisions in the contract? HCWU reserves the right to comment on, oppose, or monitor any plan. This is after you've presented all your facts. Number 9, the board reserves the right to modify these criteria. Who would suck into something like that? You keep moving the goalpost. When we filed, there were 4 criteria that were approved and were the rules of the game when we filed. We meet those 4 criteria. Then, 5 days before this meeting, which, by the way, we had to call because the board wasn't giving us an audience, they come up with 5 pages that not only move the goalpost, but then reserve the right to move the goalpost again. Who would sign up for anything like that? What they have done, if these are approved, is prevent anybody from ever changing their water, period.
But their job is to protect us.
I couldn't agree more. And these were the rules that we had at the time we filed. And if you keep changing the rules...
We've told you several times you have to comply with the decree.
And this was the resolution that was in order at the time we filed.
And the decree was in place too, and a lot of these criteria come out of the decree.
I've been a lawyer for 25 years. If I wanted to prevent somebody from ever doing anything, I'd come up with a list like this. If I wanted to protect somebody, I'd come up with a list like this.
I agree, the criteria are difficult, but the association's bound to them. They're bound to the obligations it has in its decree, in its settlement agreements, in its CWCD loan, which may be an easy one to overcome. I was talking to Matt about that today. But it is the association's obligations that the association should make sure are met, and
Settlement agreements do not restrict the ability to amend the augmentation plan.
no, but the settlement agreements and the decree itself are very specific, that the settlement was based upon this augmentation plan being for agricultural irrigation. And if you change that, there is the possibility that the settlement agreements themselves could be aggressive. And that doesn't mean it's dead.
So
I mean,
how would you prove the
Please
negative?
don't interrupt.
How would you prove the
I would
negative?
assume that if you go through the process and the settlement agreements are at risk, or if there's something else required with those parties to agree to the amendment to the augmentation plan, that the applicant would be responsible for covering all that, not the association. So it's a process that has to be gone through. I agree with that. It is not a cheap process. I would like to think that some of the assumptions they've made will prove out. That would be great for the association.
Well, that's why we have the motion before us. It's up to the members. It's not up to people that can draft a 5-page document. It's up to the members. If they want to have the ability to move it forward, we can do it and we can protect you. If you pass the motion, we can move on.
So if we had somebody come up and want to buy our water, somebody else, we couldn't do it. They wouldn't want to buy it.
Would you?
No, I'm just saying that if someone else, like a lot of us want to do, to sell our water, if someone else from Timbuktu come up here and had $60 million, like everybody's asking, why would they buy it? If they can't do anything with it, they're not going to.
Okay, let's go back to, it's their job to protect us. If that's what they're looking out for our best interest, we need to listen to them and listen to them carefully. No offense, but you're here to make money. Okay.
No, I'm here to protect my water rights also.
But
this
you're
will
changing
do it.
your augmentation plan so you can make money. And that's
No,
fine, I don't care, but
Be
they're trying
clear
to
about
make
this.
sure we're not.
We're going to add.
Chris,
we're going to add a unit.
Chris, let him finish, please.
Okay, I'm done. I just want to make sure you're here to make money, and I can understand that. That's your business. But they're here to make sure none of us are harmed. And that's all, we need to keep that in mind.
Do you know one of the criteria in here is to make sure that reed cattle specifically is protected?
That was part of the agreement in my.
Yeah, and in that agreement,
Okay.
he said he would be held harmless from that point forward by that payment. Now he's adding it as a different specific criteria in this plan, and his lawyer is supposedly representing us, right?
Yeah, I represent the association, yes.
And do you represent John Reed too?
I represent Reed County.
Yes. So he represents both. And that is one of the criteria that's in here.
Okay. Yeah,
So he's here to make money, and I'm here to make money, and I assume you're in the cattle business to make money, right?
Everybody's making money.
Exactly. So
But
what?
your analysis is to your benefit.
Did you do any analysis to determine whether you were going to injure your neighbor by pumping your wells?
That was already done, wasn't it not?
No,
By the
you didn't
state
have to.
engineer?
You didn't have to, because the augmentation plan covers everybody. And as long as you're on the number of acres that you're on, and as long as you're not violating your decree, it is assumed you aren't injuring anybody. We've gone the next step, which is when you add a use, we've got a ratio of dry up that protects everybody based on the past history of the association.
You know, if they can get through the court case and meeting these criteria, great. The association has obligations. We've tried to set it out in one document, and you know, you're right. It would benefit the whole association if this can go through without hurting other people in the association. Yeah.
Does the OG plan, based on paragraph 6.3 and 6.4, protect industrial use? If it
No.
comes back in?
No. Nothing about the augmentation plan is designed to and specifically says, this plan is designed and contemplated only for agricultural irrigation.
But you're using the 35 CFS as protection, right?
Yes, yeah.
But they're not protected under the OG plan.
Not yet. They would have to amend the augmentation.
All right.
Yeah.
That's what I was asking.
Yeah.
So you now have to amend the augmentation plan.
I believe so,
if-
yes.
If they're successful.
Yeah.
That's what they're applying to do, isn't it?
Yes.
Now, there is a precedent, however. When Pricer bought 2 CFS of the Box Springs right, he bought it for all use and to export it out of the basin. Horse Creek Water Users Association agreed with that analysis and got paid for it. Reed agreed with the analysis and got paid for it. The state agreed with that analysis and said it would, the Box Springs 2 CFS would allow for export. So we're just using that same approach.
Why don't we just approach Pricer and use that water?
Pardon?
Why can't we use Pricer's water to do the same thing?
He owns it.
But that raises a good question, because one of the ideas we've been trying to think about is how can this work without risking changes to the augmentation plan that would be adverse to other members. There are some ideas now. We haven't really fleshed them out, but one is the possibility of purchasing more Box Springs water and doing a separate augmentation plan in an attempt to mimic our current augmentation plan that covers these non-agricultural irrigations. And that is a possibility. That's what Mr. Pricer did. He bought his own augmentation water and did his own augmentation plan, his wells for irrigation wells. And so there might be some other ideas. There might be some other ways to do this. I know the association has the potential to maybe buy some Box Springs water, right, to do this. It's just a matter of getting it through the process to make sure that there's no injury to the association. There's no adverse effects on the augmentation plan that would adversely affect the other members of the association.
So the 35 CFS has already been changed to augmentation use generally, and so the augmentation plan itself does not currently authorize industrial use, but the source of augmentation in the plan does, so that's why we don't have to do the CU analysis. We add the use to the aug plan, and basically you're taking water out of this column. You're not going to irrigate as much. You're moving it over here, and you're going to have industrial use, but the total amount won't be more. So
why would a guy want to buy more water from Box Springs if they don't think there's any water anyway? Just spending more money.
I was reading on the internet, see that stuff, and it says Colorado is, 20% over adjudicated the water in the state anyway, and that any new criteria is going to have to, or anybody wants to change something, they're going to ask for, and we'll lose some water right. I don't remember the exact wording. What have you read on that?
are you talking about if you do a change of water rights, you lose some
Yeah,
of
if you
your
change the water rights, you're going to lose 20%, right?
Well, if you change a water right, you're limited to how it was used historically, so you can't use the water in the as much of the water in the future as you had in the past. But that's not what we're proposing to do
This
here.
don't have any effect on that.
We're not proposing to do a change of water rights.
Okay, I
We're just, we're gonna have, you know, if there was, whatever the number of max depletion under the plan is, we're still gonna have that same cap on all depletions. It's just now, rather than it only being irrigation depletions, you're gonna have industrial plus irrigation equals the same number.
Okay. I just have to remember that. I just want to kind of clarify that. Sometimes I read some of it. You want to put,
Yeah, but if you have a use change like that, doesn't it still substitute you to an industrial change that you can be restricted that much? Even though you're saying it's easy to do because you're drying up this or this?
We're adding a use to the OG plan. We're not doing a change of use.
Kind of hard because you're saying you're going to go industrial with it, so it's still a change of use in a certain way, right?
The issue, the box spring right was changed to augmentation of any use, and so by having your well
You
get,
have to change the use of your well to make
you have to get a new permit that allows you to.
Doesn't that make it a change of use then?
No.
You use the augmentation ratio to change your well.
And you have to get a new well permit, but you don't have to get a new water right.
And that's one of the assumptions that if it proves out, would be great. I think that's the procedure they've got to go through, because there is potential, and we've discussed this with them, that someone could jump in and say, no, what you're doing is you're changing the nature of augmentation, and so you've got to reconsider how much box spring water is. Nobody wants that to happen. They don't want that to happen. The association doesn't want that to happen. And so if it can go through under those assumptions, that would be great.
What is the likelihood or probability that it will go through those? Is it, if you could take a guess, 90% probable it's going to happen that way, or 50%?
All I can do is tell you what other people have told us. The division engineer told me that he recommended we not try to change the augmentation plan to avoid these potential risks. I understand that some of the opposers in the previous case are preparing to oppose this case. And every case is different. Now, I have been involved in augmentation cases where it was a change of the augmentation case and it changed everything. I would like to hope that this could go through without changing everything to the detriment of any of the members. I mean, that's the hope.
If I could jump in, let's say an objector does come in the case and say, you have to do a change of water rights. You have to do a CU analysis. We didn't ask the court for a change of water rights. So even if we were to say, oh, we agree with you, we don't have that request in front of the judge, we would have to amend our case to even get to the point of seeking a change of water rights. The judge wouldn't have what's called jurisdiction. He wouldn't have jurisdiction over a change of water rights on the box spring right, because we didn't ask for that. So if someone says our theory is wrong, we feel very confident it's not, but if someone were to say, you have to get a change of water rights, we haven't asked for that. So the judge couldn't say, the judge can't approve a change of water rights and limit the box spring right, because we didn't ask for it. He would have to deny our application, I guess, in theory. But he couldn't say, okay, now you're stuck with CU, a limited consumptive use on your box spring right.
Also, we're talking about a conversation with the division engineer. We had a later conversation with the division engineer, and he did not give us advice not to do it. He didn't say that he wouldn't support it. He specifically approved of the analysis that we did.
Julia.
So we'll take the risk of somebody trying to recharacterize what we do, but that's not what we're asking you. We're not asking you to pay for the litigation. We're paying for the litigation. All we're asking is for you to support the addition of industrial use. If nobody here ever wants to market their water for industrial use, then don't vote in favor of that. All we're asking is, do you want to open up the possibility? All of the issues about can it happen, will somebody from the lower basin destroy the decree, all of those what ifs, but ifs, we're taking the risk on it. All we're asking tonight is to let us move ahead with the application. We still got to get past all the individual objectors. I don't care if it's the Box Springs people, we'll take that chance. I don't care if it's the state engineer, we got to meet whatever he's saying we got to meet. We'll take that chance. But what we are asking is that the members here that want to have the potential sometime in the future to have an additional use, give us the go-ahead tonight.
Let me ask one thing. You mentioned that you would take all the risk.
Yes.
Okay, and then you get into it, and then it does get opened up. How do you take the risk and that jeopardizes all of us? How do you
So,
do that?
are you telling me that there's no way I could meet these criteria of guaranteeing you that there is no risk? Is that what you're saying, Jack?
No, I'm asking you. You say you're taking all the risk.
We are
and
taking
you
all the
open
risk.
this all up, and they do, of course, do say, wait a minute, this opens up the whole deal, and it's subject to change then, okay? And so we're all here, and if you're taking all
cannot
that
change
risk, how do you
somebody's-
do that to represent all of us? Because if you want the association to give you approval and support on this, then you're representing all of us here.
No,
And
I'm
so,
not.
well, in a way you are, because you're taking our whole plan that everybody has a piece of and want to amend the whole thing. And so if we support this, you're representing all of us, aren't you?
No.
And,
We're representing the co-applicants. If you want to be an applicant and control the destiny of this, then be a co-applicant. If you don't want me to speak for you, be an applicant.
By support, do you mean that the association won't oppose the application?
I'm saying support. You can either be a co-applicant or not object.
Okay, so that's what you mean, don't object to the application?
No, I'm saying if you want to be a co-applicant and control it, you ought to jump in. That's
But
the.
what do you want the association to do? Do you
That's what
want
I'm
them to
saying.
agree not to oppose the application?
It's either or. If the board wants to be a co-applicant, they can control it that way.
Okay, what do you want the association to, are you asking the association to agree not to oppose the application?
I want them to support it.
Okay, does that mean you don't want
It
to
means
oppose it?
not oppose,
Okay.
obviously.
Great.
And it also means they could be a co-applicant. It's either one of those.
Yeah,
I think that's within the scope of the vote request.
I'm sorry?
It's within the scope of the requested vote. Is it considered, you're just going to say, we support what you're doing, we don't want to be a co-applicant, or we're
You can
supporting
be-
what you're doing and we want to be at the table as a co-applicant?
Okay,
But we
because
support
I just
the
wanted to
engineering.
clarify
and
what you meant by support, and I understand that it means you don't want the association to oppose the application.
Right. But I mean, it goes way beyond that. It's an opportunity for everybody here to have an additional use.
Dean, did you have a question?
I did. I want to ask you, those to do various conclusions of consumption use, you go to court to try to change the water to this little contract. Would that be considered speculation because it is such a little contract, because it will expire in a year or so, and it's just easier for us to do speculative?
There is the potential for it. Speculation is somewhat of a fluid concept. But the purpose of speculation is to prevent someone from taking water out of use, in its current use, when they don't really have a stated use for it yet. It can be in volume, amounts, it could be in timing, the issue of just a one-year contract is a potential issue with speculation.
So this is just an easy way to make it.
Well, except for it's not easy, yeah.
Well, it's easier to use.
Yeah, I think what you're talking about is if they were to, if anyone were to say, we want to do this, and you end up with a situation where other people are making you do consumptive use analysis on either your pumping and how much augmentation water you're allowed based upon your pumping, or on the change of the augmentation water that you want to use, that, you know, that there are possibilities for individuals to do that and those issues to work through. So it's going to be, there are possibilities for doing it as a whole. There are possibilities for doing it as a separate augmentation plan.
The chances are a lot slimmer because
Yeah, speculation is a big issue for people in water, yes.
But not.